Thank you, Mr. Anirudh, for joining us today, and I welcome all the participants and Mr. Anirudh. I'm Madhumati here. I'm the Deputy Secretary of the Madras Chamber, and I'm the Registrar of the Madras Chamber's Arbitration and Conciliation, Mediation and Conciliation Center. I don't think Madras Chamber requires an introduction to any of you because most of you are members. We are in our 185th year of service to trade and commerce, and we've been one of the first few organizations to provide arbitration services for resolving commercial disputes to our members. We have recently set up an exclusive arbitration center with the state-of-the-art facilities in our computer center just adjacent to our office and in our own premises. We'll be sharing more details about our center with you, our names as well as the website, and you can feel free to be in touch with us for availing the services. We are organizing this arbitration series for the past 4 or 5 months, and in fact, this is the fifth in the series. We've had experts addressing us on the various aspects of institutional arbitration in India, and this is the fifth where Mr. Anirudh Padwa will be talking about the independence and impartiality of arbitrators. I welcome you once again, Mr. Anirudh, and all the participants. And before I pass on the session to Mr. Anirudh, I would like to do a brief intro of Mr. Anirudh. Mr. Anirudh is a partner in Vadhva Law Chambers, and he's a graduate of the National Law School of India, University of Bangalore, and University of Oxford. He is the co-chief editor of Justice R.S. Bachawat of Arbitration and Conciliation in India, and the chief editor of the Mullah of Indian Contract Act. He has previously served as an expert consultant and advisor to the Honorable Law Commission of India for the 246th report suggesting reforms and amendments to the Arbitration and Conciliation Act 1996. It's a privilege to have you, Mr. Anirudh, and I would like to add that Mr. Anirudh Krishnan, who is part of our governing council, is also the co-author of Justice R.S. Bachawat on Arbitration and Conciliation in India. It's a pleasure to have you, Mr. Anirudh, and over to you now. You can make the presentation and take up the questions after the presentation. I request all the participants to post your questions in the Q&A box so that you can hear from Mr. Anirudh. Thank you. Over to you, Mr. Anirudh.
Thank you, Ms. Madhu, for such a kind introduction and for those words. The topic today for the talk is independence and impartiality of arbitrators. Now, this is a topic which has raised a lot of questions in recent times, and there has been a lot of legislative developments as well as judicial pronouncements on the issue of independence and impartiality of arbitrators. My aim in this talk would be to take you all through the various principles underlying the concept of independence and impartiality of arbitrators, the statutory scheme in the Arbitration and Conciliation Act, and how the law has evolved from the times of the 1940 Act to the 96 Act to the 2015 amendments in the 96 Act to the recent judicial pronouncements, and where in the law do we stand now and what is the way forward. Now, to start with, I just thought it would be useful to just do a brief recap on what are the principles of arbitration, what exactly underlines an arbitration, how is an arbitration different from other forms of alternative dispute resolution, and in that context, where does the concept of independence and impartiality come in? Now, there are various methods of ADRs or alternate dispute resolutions, as we know. Arbitration is one such method. Given that our court system and the judicial system in general is clogged, it is slow, there has been a trend amongst the business community to resolve the dispute through these various methods of ADR. So you can categorize the various ADR methods from the least formal to the most formal. So a negotiation is a method of ADR for resolving disputes where parties mutually discuss and try and negotiate or attempt to amicably settle a dispute without the intervention of any other person and without a statutory backing. That method of ADR is called negotiation. A mediation is something more formal than negotiation. A mediation is where there is a mediator who is appointed, who would attempt to guide the parties to find a solution. Conciliation is something even more formal than a mediation, where there are provisions in the Arbitration and Conciliation Act. There's an entire chapter there which deals with conciliation, where there are requirements of who a conciliator can be, how a conciliator is to be appointed, what a conciliator can do, how information is to be exchanged between the parties before a conciliator. And the aim of a conciliator, like a mediator, is to guide the parties towards negotiating an amicable settlement. A conciliator, a mediator, cannot make an award which is binding on the parties. The only form of binding dispute resolution is arbitration, which is defined in the Arbitration and Conciliation Act, where parties choose to resolve their disputes through a neutral third party who's called an arbitrator. The arbitrator decides the disputes in a formal manner, although not as formal as the principles of law in the CPC, but still fairly formal in terms of the principles under the Arbitration and Conciliation Act. And the arbitrator's decision results in an award. That award is binding on the parties. That award is executable like a decree of the court. So you can go to court and get that award executed. You can get that award enforced against the party against whom the arbitration has taken place. And that award is a formal decree of the court. That award can be challenged on only very, very limited circumstances. So, in that sense, arbitration is a binding and a contract based alternative dispute resolution mechanism where parties, by their contract, choose who is to be the arbitrator, how the arbitration process is to take place, and that results in a binding award. Now, the hallmark of an arbitration is the concept of party autonomy, what lawyers call as create your own arbitration. So, theoretically, you can choose any person to be your arbitrator, you can choose any law to govern your arbitration, you can choose any place in the world to be your seat of arbitration, you can set down any standards, you can lay down your own fees for the arbitrator. So, an arbitration is a highly customizable method of dispute resolution. The principle of arbitration is party autonomy. So, parties can agree how their dispute is to be resolved and how the arbitration process is to move forward. Now, the concept of party autonomy is sits uneasily with the concept of minimum standards. Now, what do we mean when we talk about minimum standards of arbitration? Now, there are some things which are very important in a dispute resolution mechanism. It is important that reasons are given for the decision. It is important that parties are heard. It is important that parties have opportunities of presenting their case before the arbitrator. Since an arbitration process replaces a formal dispute resolution process through the court, it is all the more important that these minimum standards of what we call as procedural and substantive fairness are present within the arbitration system so that a party's rights are not prejudiced or are not affected if a party goes in through the process of arbitration. Now, of course, there is a dichotomy between party autonomy and minimum standards. Party autonomy, on the one hand, says that you can choose your arbitration, you can choose however you want your disputes to be resolved. The concept of minimum standards is completely opposite to that. The concept of minimum standards uh, implies that there are certain standards inherent in a dispute resolution process which, even if the parties want, they cannot waive or they cannot contract out of. Now, this is an uneasy but an important balance. The concept of independence and impartiality of the arbitrator is one such minimum standard. Now, since arbitration is a method of resolution of disputes, it is important that the process or this method is seen as being fair and above board. And what is more important than ensuring that the person who's deciding your dispute is independent and impartial? Now, there is a distinction, there is a formal distinction between independence and impartiality. They are used by lawyers as terms of art. Arbitrators also refer to them as terms of art. These two terms are similar, but they are not synonymous. They are not, in that sense, interchangeable. They may overlap to some degree. The Supreme Court had occasion to discuss this in a recent case called Voestalpine versus DMRC, where the Supreme Court said this: independence and impartiality are two different concepts. An arbitrator may be independent and yet lack impartiality, or vice versa. Impartiality, as is well accepted, is a more substantive concept as compared to independence. Independence, which is a more objective concept, may thus be more straightforwardly ascertained by the parties at the outset of the arbitration proceedings in light of the circumstances disclosed by the arbitrator, while partiality will more likely surface during the arbitration proceedings. Now, independence as a concept is an objective concept. A arbitrator is either independent or he is not. There are objective standards for determining whether the arbitrator is independent or not. If the arbitrator is a managing director of one of the parties, if the arbitrator is an employee of one of the parties, if the arbitrator is a shareholder of one of the parties or controls one of the parties, surely that arbitrator is not independent. The concept of impartiality is something more subjective, it is more abstract. It is whether the arbitrator, being in the position that he is and having all the trappings of the person that he has, can he bring a fair play of mind to decide a particular dispute without bias, without the appearance of bias. So, for instance, to give a very loose example, if there is a dispute between two countries which goes in for arbitration, whether the national of one of those countries can be said to be impartial. Usually, in these sort of matters, impartiality is a more subjective, more abstract concept, but it is an important concept if, on account of your standing or position, you cannot bring a fair mind to decide the dispute before you, then perhaps you are not fit to decide the dispute. You should not be an arbitrator. You are violating the concept of impartiality. Now, Indian law on arbitration has always recognized independence and impartiality as being an important attribute of the arbitrator. Though the law has kept changing, it has kept evolving, the standards have also kept improving or perhaps getting more strict. Now, the Arbitration Act of 1940 did not have any particular requirement for independence or impartiality of an arbitrator. However, it was implied that an arbitrator should be independent and impartial. The court could remove an arbitrator for misconduct under Section 11(2) of the 1940 Act. Misconduct was defined to include a situation where the arbitrator is not impartial or not independent. Now, the 1996 Act for the first time brought about expressly the requirements of independence and impartiality as part of the law governing the arbitration process. Sections 12 to 15, on which I'll come to in a moment, they deal with the procedure for challenge to the appointment of an arbitrator where there are justifiable doubts as to his independence or impartiality. And these sections 12 to 15, along with certain other provisions in the Arbitration Conciliation Act, lay down a complete code dealing with the requirements of independence impartiality. Yet perhaps the law was not enough. There was a Law Commission report which came out in the year 2014, the 246th Law Commission report, which suggested numerous changes to the Arbitration and Conciliation Act. But some of the most important changes were in the context of ensuring independence and impartiality of the arbitrators. And significant amendments were made to the Arbitration Conciliation Act by the 2015 Amendment Act, which followed the 246 Law Commission report. Because of these changes, now the requirements of independence and impartiality have been laid down in much more detail. We have borrowed the standards from from the International Bar Association guidelines, which are the standards which are used across the globe. And now our law mirrors the international standards, and there are significant requirements laid down in the law to ensure that the arbitral process remains fair, remains above board, and the arbitrators remain independent and impartial. Now, the applicability of the 2015 amendments, this is on whether it would apply to a particular arbitration or not. Now, this is a fairly technical legal point. It depends on Section 26 of the 2015 Amendment Act, which laid down certain requirements. The Parliament brought about Section 87 of the Arbitration Conciliation Act, which has been struck down by the Supreme Court. So therefore, we go back to Section 26 of the 2015 Amendment Act. But take it that if your arbitration has started after 23rd of August 2015, then you would be covered by the amendments. If it has started before, then maybe you are covered, maybe you are not. There are a number of legal issues which arise over there, but they are not the subject matter of this talk. Now, the first and perhaps the most important judgment prior to the 2015 Amendment Act is the judgment of the Supreme Court in the case of Indian Oil Transport versus Raja, Indian Oil Corporation versus Raja Transport. Now, this was a case where the arbitration clause of Indian Oil Corporation provided that in the event of a dispute between Indian Oil Corporation and any of its contractors, the dispute would be resolved by a serving officer of Indian Oil Corporation. Now, this clause was challenged since a serving officer of one of the parties can never be said to be independent or impartial. The matter ultimately reached the Supreme Court. The Supreme Court had a number of interesting observations in this case. They observe firstly that while the provisions relating to independence impartial are more explicit in the 96 Act, it did not mean that the Arbitration Act 1940 enabled persons with bias to act as arbitrators. What was implicit under the old Act is made explicit in the new Act in regard to impartiality, independence, and freedom from bias. So, what they confirmed was that the new Act is not that radical a departure from the old Act. The old Act did not make the requirement of independence and impartiality very explicit. What the new Act does is it makes it explicit. The Supreme Court, however, unfortunately held, because of the statutory language which was there in the law at that point of time, that there is no bar in the 1996 Act for an arbitration agreement to provide for the employee of a public sector undertaking or a government corporation from acting as an arbitrator, despite the fact that that public sector undertaking or corporation is a party to the dispute. Now, this is the observation of the Supreme Court. The fact that the named arbitrator is an employee of one of the parties is not ipso facto a ground to raise a presumption of bias or partiality or lack of independence on his part. There can, however, be a justifiable apprehension about the independence or impartiality of an employee arbitrator if such person was the controlling or dealing authority in regard to the subject contract, or if he is a direct subordinate, as contrasted from an officer of an inferior rank in some other department to the officer whose decision is the subject matter of the dispute. So what the Supreme Court said was that just because you are an employee of Indian Oil Corporation does not mean that you are debarred from deciding a dispute between Indian Oil Corporation and one of its contractors. As long as you have not dealt with the dispute in your official capacity, or you are not an officer who is subordinate to an officer who has dealt with the dispute in his official capacity, you can be an arbitrator. Now, this was not a very happy decision. And in fact, we had hoped that the Supreme Court would use the change in the law in the 1996 Act to rule that an employee of a party certainly cannot be an arbitrator and decide a dispute for that party. If nothing else, even if there may be no actual bias, the person may be completely independent. He may have an impartial mind. He may bring an impartial mind to the dispute before him. Surely the issue of appearance of bias is there. To a neutral third party observer, it does sound fairly suspicious as to why an employee of a party is deciding the dispute of that party itself. It is a fundamental principle of natural justice that a person cannot be a judge in his own cause. Now, in the event of an employee arbitrator, it is exactly a violation of this principle that you are being a judge in your own cause. However, because the Supreme Court did not find any statutory backing, it was forced to come to this conclusion. Now, this case ultimately was discussed before the Law Commission of India. There were a number of, although the case did make the right observations, the situation of law was quite unhappy. And in government contracts across the board, since the government is the biggest litigant in the country, most disputes arise in the context of the government. In government contracts across the board, there was a trend to put in clauses where employees of the government corporations or PSU or government departments were to be the named arbitrators. Now, this situation was recognized by the Law Commission of India, and in its 246th report, the Law Commission commented about the unhappy situation of law which was existing. And I'll just read out the extract from the Law Commission report. The report says the Act does not lay down any other conditions to identify the circumstances which give rise to justifiable doubts, and it is clear there can be many such circumstances and situations. The test is not whether, given the circumstances, there is any actual bias, for that is setting the bar too high, but whether the circumstances in question give rise to any justifiable apprehension of bias. While the Supreme Court in Indian Oil versus Raja Transport carved out a minor exception in situations where the arbitrator was the controlling or dealing authority in regard to the subject contract, or if he is a direct subordinate, as contrasted from an officer of an inferior rank in some other department to the officer whose decision is the subject matter of the dispute. And this decision was used by the Supreme Court in Denel and Vipromas to appoint an independent arbitrator under Section 11. This is not enough. So the Supreme Court found the Raja Transport decision to not be enough. It did not satisfy the standards of independence and impartiality as was recognized throughout the globe. And therefore, wide-scale changes, amendments were proposed by the Law Commission of India, which found their way into the Arbitration Conciliation Act through the 2015 Amendment Act to the Arbitration Conciliation Act. Now, the scheme of the Arbitration Conciliation Act dealing with the concept of independence and partiality of the arbitrators is set out in section 12 to 15, primarily section 12 to 15 of the 1996 Act. Section 12 lays down the ground for challenge of an arbitrator. Section 13 lays down the procedure for challenge of the arbitrator. Section 14 talks about what happens when there is a failure or impossibility to act. There are concepts of de jure and de facto impossibility to act, which are recognized in section 14. And if an arbitrator becomes de jure or de facto unable to act as an arbitrator, there is a window open to a party to go to court and to get a ruling on that, on whether there is such a de jure or de facto inability. And section 15 talks about what happens in the event of termination of mandate and how an arbitrator is to be substituted. There are some other relevant provisions in the Act as well, which talk about independence, impartiality. Section 11, subsection 8 is a provision which says that where a court is appointing an arbitrator, then the court has to look at the requirements of independence, impartiality. Section 18 talks about equal opportunity to both parties to present their case, which also is an extension of the principles of independence, impartiality. Then schedules 5, 6, and 7, which have been brought about by the 2015 Amendment Act, are also relevant in this context. Schedule 5 lays down the various entries which do raise justifiable doubts as to the independence and impartiality of an arbitrator, and where there is a duty on the arbitrator to make disclosures. Schedule 6 lays down the form of such disclosure, and Schedule 7 talks about those conditions where an arbitrator is ineligible to act as an arbitrator, and therefore his mandate should be terminated. Now, there was a departure which was made from Article 13 of the Unsettled Model Law. Now, our Arbitration Conciliation Act is based on the Unsettled Model Law. The Unsettled Model Law is a model law which has been framed by Unsettled and is used in various jurisdictions as the basis for the Arbitration and Conciliation Act based on the New York Convention. Article 13.3 of the Unsettled Model Law provides for a procedure to approach court where there is a justifiable doubt as to the independence and impartiality of the arbitrator after approaching that arbitrator. Unfortunately, in India, we did not have that provision. The understanding was that if an opportunity is made available to go to court on the ground of lack of independence, impartiality of the arbitrator before the award, then perhaps that may delay proceedings, and therefore this step was taken away. And the requirement in Indian law is that if a challenge fails, and a challenge has to be first brought before the arbitrator himself as to his independence, impartiality, and if such challenge fails, then the only recourse available to you is to challenge the award, and you cannot challenge that order of the arbitrator rejecting the independence, impartiality. Now, section 12 lays down the grounds for challenge. I'll just read the relevant provisions of section 12 because they are important. When a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any circumstances, such as the existence, either direct or indirect, of any past or present relationship with or interest in any of the parties, or in relation to the subject matter of the dispute, whether financial, business, professional, or other kind, which is likely to give rise to justifiable doubts as to his independence or impartiality. So 12.1a requires an arbitrator to make disclosures of a fairly uh, uh, large large set of relationships which are likely to give rise to justifiable doubts as to his or her independence or impartiality. Now, explanation 1 is linked to 12.1a. Explanation 1 says the grounds stated in the fifth schedule shall guide in determining whether circumstances exist which give rise to justifiable doubts as to the independence or impartiality of an arbitrator. And explanation 2, the disclosure shall be made by such person in the form specified in the sixth schedule. So, like I mentioned, the fifth schedule lays down a number of instances which, if exist, require the arbitrator to make a disclosure in the form which is laid down in the sixth schedule. The other relevant provision is 12.5, which says, notwithstanding any prior agreement to the contrary, any person whose relationship with the parties or counsel or the subject matter of the dispute falls under any of the categories specified in the seventh schedule shall be ineligible to be appointed as an arbitrator, provided that parties may, subsequent to disputes arising between them, waive the applicability of this subsection by an express agreement in writing. So while 12.1 requires the arbitrator to make disclosure if the grounds stated in the fifth schedule exist, 12.5 says that if the grounds specified in the seventh schedule exists, then you are ineligible to be an arbitrator, and that's not an issue of disclosure anymore. That's an issue of ineligibility. Now, 12.1a, what I have underlined, as well as 12.5, has been added by way of the 2015 amendments. These grounds, or specifically the references to the fifth schedule and the seventh schedule, was not there prior to the 2015 amendment. What's also relevant as part of 12.5 is that although you may be an arbitrator who's barred under the seventh schedule, there may be situations where, after disputes have arisen, parties still want you to be an arbitrator. So in that case, 12.5 is waivable, but it is waivable only by an express agreement in writing. It's not waivable by conduct or through an oral or verbal agreement. And that such an agreement has to be after disputes have arisen between the parties. So, for instance, if a arbitration clause today provides that the employee of one of the parties is to be an arbitrator, that is hit by section 12 subsection 5, because entry 1 of the 7th schedule prohibits an employee of a party from being an arbitrator. But if after disputes have arisen, parties agree that an employee can be an arbitrator, then 12.5 is waivable. So in that sense, it strikes a balance between party autonomy and minimum standards. Now, section 13 talks about the challenge procedure. The relevant provisions are section 12, section 13, subsection 1, 2, which say that parties are free to agree on a procedure for challenging an arbitrator. This is a reference to party autonomy, that they can decide how they want to challenge the arbitrators. Of course, that's at the time of entering into the arbitration agreement itself. And failing any agreement, within 15 days after becoming aware of the constitution of the tribunal or any of the circumstances which are referred to in 12.3, they can send a written statement of reasons to challenge the tribunal. So they can make an application before the tribunal itself under section 13.2 to get a recusal or to get an order on whether the arbitrators are capable of proceeding with the arbitration. Now, 12.3 says, unless the arbitrator withdraws from the office, the arbitral tribunal shall decide on the challenge. So, 13.3 is important. 13.3 gives the power to decide on the challenge of independence and impartiality to the arbitral tribunal itself. And 13.4 lays down the rule that if the challenge procedure is unsuccessful, then the tribunal has to continue the proceedings and make an arbitral award. So then there is no other scope for you to approach court. You have to challenge only the award. And of course, the ground of lack of independence and partiality is something which can then be considered by the court. And the order passed by the arbitrator under 13.3 or 13.4 can then be challenged only before court under section 34. Now, section 14 talks about failure or impossibility to act. Now, as I had mentioned, 14.2 gives an option to a party to apply to court to decide on the termination of the mandate if there is a de jure or de facto inability to perform the functions. This has been interpreted, as I will come to the judgments later, to say that where any of the conditions in the 7th schedule are satisfied, you can approach a court under 14.2 and get a court to rule on the ineligibility of the arbitrator, seek the termination of the mandate, and get a substitute arbitrator appointed. Section 15 talks about appointment of a substitute arbitrator. Now, Schedule 5 of the Arbitration Conciliation Act is linked to 12(1)(b), which is the requirement of disclosure. Schedule 5 has 34 entries. It is based on the green and the orange list of IBA guidelines on conflict of interest. Now, these IBA guidelines on conflict of interest are very interesting. These are guidelines essentially which have 3 lists: the green list, the orange list, and the red list, where various situations which give rise to a conflict of interest or a perceived lack of independence and impartiality on the part of an arbitrator are laid down. And these situations are classified into these 3 lists: green, orange, and red. The green list has those situations where there is no conflict of interest or the matter is green. The orange list are those lists where perhaps there may be an issue of a conflict of interest. The requirement is, if your relationship or your situation falls within the orange list or the green list, you have to make a disclosure. There is what is called as the red list as well. The red list are list of those situations where a disclosure is not enough. In fact, if your situation falls within the red list, then you are ineligible to be an arbitrator at all. Red list is part of Schedule 7. The green and the orange list are part of Schedule 5. The green and the orange list or Schedule 5 has 34 entries. These are classified into 7 subheadings. First is arbitrators' relationship with the parties or the counsel, relationship of the arbitrator to the dispute, arbitrators' direct or indirect interest in the dispute, previous services for one of the parties or other involvement in the case, relationship between an arbitrator and another arbitrator or counsel, relationship between arbitrator and party and others involved in the arbitration, and then there are some miscellaneous situations. The Schedule 6 of the Arbitration Conciliation Act has also been brought in by way of the 2015 amendment. It lays down the format for declaration to be made by an arbitrator. The disclosures required in terms of Schedule 6 are contact details, obviously, the prior experience of the arbitrator, the number of ongoing arbitrations. In the context of our talk today, this is important: the circumstances disclosing any past or present relationships with or interest in any of the parties or in relation to the subject matter in dispute, which is likely to give rise to justifiable doubts as to your independence or impartiality. So here the disclosure requirement is linked with 12(1)(b) and the 5th schedule. Now, the Punjab and Haryana High Court has held that it is not mandatory to give a disclosure if no circumstances exist which give rise to justifiable doubts as to independence and impartiality. So, although there may be a situation which could be grey or maybe part of an orange list or the green list, if it does not give rise to a justifiable doubt, there is no requirement to make a disclosure. A case where an improper disclosure was made and the Delhi High Court came down heavily on the arbitrator is the case of Dream Valley Farm versus Religare Finvest. Now, in this case, the arbitrator had made a declaration, a simple declaration stating that he had been presiding over 20 arbitrations. He did not mention that most of those 20 arbitrations were connected with one of the parties to the dispute, which was Religare Finvest. Now, after the proceedings had commenced, disclosures were sought from the arbitrator. It came to the knowledge of the party that this arbitrator was a routine arbitrator of Religare Finvest, and further disclosure by the arbitrator revealed that he had been serving as an arbitrator in 27 matters related to Religare Finvest. Now, the court held that in such a situation, while Section 13 application would be the normal course for a party to take, which is you challenge the independence, impartiality of such an arbitrator before him, and if he rejects, then you challenge only the arbitral award. But in the facts of this case, the court said that since there was a clear suppression of material facts and there was a case of deliberate or malified non-disclosure, the the mandate of the arbitrator can be said to be de jure terminated, and he is disqualified from continuing in his position as an arbitrator, and the court accordingly terminated his mandate and appointed another arbitrator. Now, Schedule 7 of the Arbitration Conciliation Act is linked to Section 12, subsection 5, which is based on the non-waivable red list of the IBA guidelines on conflict of interest. There are 3 subheadings here, and there are 19 entries. The arbitrator's relationship with the parties or counsel, relationship of the arbitrator to the dispute, and arbitrator's direct or indirect interest in the dispute. Now, in terms of the proviso, none of the situations in Schedule 7 can be waived. And they are waivable only by an express agreement in writing, and that too after disputes have arisen between the parties. So, like I mentioned, a clause which provides for the managing director of a party to be an arbitrator would not be valid ordinarily, but if after disputes have arisen and parties have entered into a written agreement consenting to such a procedure or consenting to such a clause, then that overrides the requirement of Section 12, subsection 5. Now, the rationale for this is laid down in the 246 Law Commission report. This amendment is in consonance with the principles of natural justice. That an interested person cannot be an adjudicator. This incorporates the principles of the provisions of the waivable and the non-waivable red list of the IBA guidelines of conflict of interest. However, given that this clause would be applicable to arbitration in all contexts, including in family settings, it is advisable to make these provisions waivable, provided that parties specifically agree to do so after the disputes have arisen between them. So, what the Law Commission of India was perhaps envisaging was a case of a family settlement, where one of the elders to a family who may have an interest in the dispute is consented to by all the family members to resolve the disputes between the parties. Since the principles of impartiality and independence cannot be discarded at any stage of the proceedings, specifically at the stage of constitution of the arbitral tribunal, it would be incongruous to say that party autonomy can be exercised in complete disregard of these principles, even if the same have been agreed prior to the disputes having arisen between the parties. Now, this is the dichotomy which I was talking about between party autonomy and minimum standards. There are certain minimum levels of independence and impartiality that should be required of the arbitral process, regardless of the parties' apparent agreement. A sensible law cannot, for instance, permit appointment of an arbitrator who is himself a party to the dispute or who is employed by or similarly dependent on one party, even if this is what the parties agreed. The Commission hastens to add that Mr. So-and-so, the ex-officio member of the Law Commission, suggested having an exception for the state and allow state parties to appoint employee arbitrators. The Commission is of the view that on this issue, there cannot be any distinction between state and non-state parties. Concept of party autonomy cannot be stretched to a point where it negates the very basis of having impartial and independent adjudicators for resolution of dispute. In fact, when the party appointing an arbitrator is the state, the duty to appoint an impartial independent arbitrator is that much more onerous, and the right to natural justice cannot be said to have been waived only on the basis of a prior agreement between the parties at the time of contract before arising of the dispute. Now, HRD Corporation is one of the first judgments of the Supreme Court. I'll just come to the various judicial pronouncements now interpreting the 2015 amendments. HRD Corporation is one of the first judgments of the Supreme Court which discussed the consequences of the various changes brought about by the 2015 amendment. Now, this was a case where a challenge was made to two arbitrators, one to the presiding arbitrator and one to a party nominated arbitrator, in this case, the arbitrator nominated by GAIL. Now, in the case of the arbitrator nominated by GAIL, one Justice Dwabia, the facts were that he had previously rendered an award between the same parties. So, between HRD and GAIL, Justice Dwabia was an arbitrator, and that award concerned similar or the same disputes. It arose out of the same facts. There were, in fact, 4 separate arbitrations which were taking place between the parties, and Justice Dwabia was an arbitrator in one of them. In the case of Justice Lahoti, the facts were that he had advised or given an opinion to GAIL, but in an unconnected matter. And the other fact was that since Justice Dwabia had participated in the appointment of Justice Lahoti, Since Justice Dwabia's appointment was stated to be bad, then Justice Lahoti's appointment also could not stand. Now, the matter reached the Supreme Court and it was held there is a distinction between Section 12, subsection 1 and subsection 5. The requirement of disclosure is there in terms of Section 12.1 in the 5th schedule. Disqualifications are there in the 7th schedule. They said Section 14, which is an application to the court to challenge the mandate of an arbitrator, is maintainable where there is a violation of the 7th schedule. And in the facts of this case and on a reading of the various entries in the 5th and the 7th schedule, the challenge to both the arbitrators were rejected. Now, I'll not read this passage. Take it that in this passage, they've drawn a distinction between 12.5 and 12.1 and the various and the requirement of making a disclosure and the disqualification. Now, in the case of Justice Dwabia, the finding of the Supreme Court was that the fact that Justice Dwabia has already rendered an award in a previous arbitration between the parties would not by itself, on the ground of reasonable likelihood of bias, render him ineligible to be an arbitrator in a subsequent arbitration. We are satisfied that there is no real possibility that Justice Dwabia will not bring an open mind and objective judgment to bear on arguments made by the parties in the fourth arbitration, which may or may not be different from arguments made in the third arbitration. Now, on Justice Lahoti said, since Justice Lahoti had only given a professional opinion to Gale, which has no concern with the present dispute, he's clearly not disqualified under item 1. Here they are talking about item 1 of the 7th schedule. Now, TRF is the second important case. This was a case where the arbitration clause provided that any dispute or difference between the parties in connection with the agreement shall be referred to sole arbitration of the managing director of the buyer or his nominee. Now, in this context, the Supreme Court said that the managing director of the buyer can certainly not be an arbitrator. Since he cannot be an arbitrator, he also cannot nominate anybody else to be an arbitrator. Now, this passage just lays down the logic for that principle. The next important judgment of the Supreme Court is the case of Voestalpine. This was a case where disputes arose between Voestalpine, which is a foreign corporation, and Delhi Metro Rail Corporation. The arbitration clause provided for Delhi Metro to give a panel of 5 names to the contractor, in this case Voestalpine, and from this panel of 5 names, Voestalpine was to make the selection of one person as their nominee arbitrator. Delhi Metro could choose one person as their nominee arbitrator, and the 2 persons would then choose the third presiding arbitrator from the same panel of 5 persons. Now, it was argued that by giving a panel of 5 persons, you are choosing who I can select as an arbitrator. And although the names that you provide as part of the panel of 5 persons may be exemplary, there is certainly an apprehension of bias, because there would be this apprehension in the minds of the contractor that Delhi Metro Rail Corporation is playing pick and choose between these persons, and therefore the judgment which is rendered by by this tribunal of 3 persons from the 5 names picked by DMRC would not be above board, or it would not satisfy the requirements of independence and impartiality. Now, although the Supreme Court did not directly comment on whether having a panel in the first place at all satisfies the requirements of independence and impartiality, the Supreme Court did say that the panel, if it exists, has to be a broad-based panel, and providing a contractor with a panel of 5 names is really illusory. It does not satisfy the requirements of independence and impartiality. And I'll just read the relevant extracts from the judgment. It cannot be said that simply because the person is a retired officer who retired from the government or other statutory corporation or public sector undertaking and had no connection with DMRC, he would be treated as ineligible to act as an arbitrator. Had this been the intention, the 7th schedule would have covered such persons as well. It therefore becomes imperative to have a much broad-based panel so that there is no misapprehension that principles of independence and partiality would be discarded at any stage of the proceedings, especially at the stage of constitution of the arbitral tribunal. We therefore direct DMRC shall prepare a broad-based panel on the aforesaid lines within a period of 2 months from today. Now, there is an issue whether having a broad-based panel in and of itself is the correct or a possible solution to the charges of lack of independence or impartiality. According to me, restricting the choice of a party to a panel whether that panel consists is broad based or is narrow based is not correct. The requirement in TRF or the requirement in 12.5 is that if there is a reasonable apprehension of bias, and that apprehension of bias would certainly exist if a party has the right to control the size of the panel, to control which persons will be part of that panel, even though they may be broad based, such a panel cannot survive. But that's not the view of the Supreme Court. The Supreme Court has said that as long as your panel is broad based, then it's all right. The next judgment is a judgment of the Supreme Court in Bharat Broadband. In this case, the arbitration clause was fairly similar to TRF. And it said that in the event of disputes, parties shall be referred to the sole arbitration of the CMD of the petitioner, or in case his designation is changed or his office is abolished, then to the sole officer of the time for the time being entrusted with the functions of the CMD, or by whatever designation such an officer may be called. And if the CMD is unable or unwilling to act as an arbitrator, then to the sole arbitration of some other person appointed by the CMD or the said officer. Now, the Supreme Court relied on TRF and said that in this arbitration clause is surely hit by the principle of TRF, and it does not satisfy the requirements of independence and impartiality. The chief managing director of a party to a dispute can surely never be an arbitrator, and they therefore struck down this clause and appointed an independent arbitrator. Now, Perkins Eastman takes the logic even further. Perkins Eastman is the most recent judgment of the Supreme Court. Here, the arbitration clause said that a dispute or difference between the parties shall be referred to arbitration before a sole arbitrator appointed by the chief managing director of the respondent, and such appointment has to be within 30 days from receipt of request of the arbitration. So the arbitration clause provided that the sole arbitrator would be the arbitrator who is nominated by one of the parties. Now, the Supreme Court extended TRS logic and said that even if the sole arbitrator nominated by one of the parties may otherwise be a person who is independent and impartial, but since the act of appointment is a unilateral act to be exercised unilaterally by only one of the parties, it does not satisfy the requirements of independence and impartiality. There is a justifiable apprehension of doubt, or there would in such circumstances always be a justifiable apprehension of doubt as to why one party has chosen that particular arbitrator and not anybody else. So all clauses now, in terms of the judgment in Perkins Eastman, which provide that one of the parties has the right to appoint the sole arbitrator, are hit by the judgment in Perkins Eastman and can now be said to be invalid. The passage of the Supreme Court is the relevant passage is para 21. I'll not read that because I'm conscious that I'm running out of time. The last judgment is a recent judgment of the Supreme Court in Central Organization for Railway Electrification. Now, this is a judgment which bucks the trend, goes against all the previous judgments of the Supreme Court. This is a case where, again, there was a panel, and the arbitration clause stated that the arbitration would be done by a panel of 3 gazetted railway officers, not below a junior administrative grade, and a retired railway officer, retired not below the rank of senior administrative grade, as arbitrators. Now, the clause provided for a panel of provided that a panel of 5 names would be shared with one of the parties, and 3 persons from that panel would be chosen as the arbitrators. The Supreme Court in this case surprisingly held that since the other party, the contractor, was given the power to select 2 names from out of the 4 names of the panel, the power of the appellant nominating its arbitrator is counterbalanced by the power of choice given to the respondent. Now, first of all, it's not correct that 2 names out of the 4 names of the panel can be selected by the contractor. The contractor can only select 1 name from the panel as its nominee arbitrator. The nominee arbitrator then, along with the nominee arbitrator of the other side, would then select the 3rd arbitrator from that panel. So that's wrong. Number 2, the more fundamental point is, why should the choice of a party be restricted to a panel of 5 names? Now, this issue was not considered by the Supreme Court, and the Supreme Court in fact upheld the validity of this clause and allowed the arbitration to proceed before this panel of arbitrators, in terms of this panel of arbitrators. Now, in light of this discussion, I think we can come to a few conclusions. Number one, I think today, with the amendments made to the Arbitration Conciliation Act, the specific statutory language, the various judicial pronouncements, it is indisputable that the requirements of independence and impartiality of the arbitral tribunal is an integral aspect of the dispute resolution. It is something which builds confidence of the stakeholders in the process. It is a requirement of natural justice. It is a fundamental principle of law that a person who is a party to the dispute cannot, or has an interest in the outcome of the dispute, cannot adjudicate the dispute. Indian law has evolved significantly from the times of the 1940 Act to the 96 Act to the 2015 amendments. The courts in general have not hesitated to strike down arbitration clauses and terminate mandate of arbitrators. The Supreme Court has consistently been expanding the scope of independence and impartiality. The judgment of Core stands perhaps as an outlier to the other judgments of the Supreme Court on this point, which have given a fairly broad and expansive meaning to the requirements of independence and impartiality. And although Core has been given by 3 judges, the judgment of the Supreme Court in TRF also is by 3 judges. So in that sense, there appears to be a direct conflict between Core and TRF, and maybe this issue may need to be decided by a larger bench in an appropriate case, and if and when the issue comes up before the court. That would be all. I'm just looking at some questions here in the chat panel. I think let's just take the last question first. When a dispute is raised to the clause of employee being arbitrator, why the agreement was signed in the first place? Well, I think the answer to that is there are numerous instances where parties really don't have much bargaining power or negotiating capacity to negotiate the contents of the arbitration clause. I mean, most government contracts, most government tenders have standard form arbitration clauses. Your contracts with banks, financial institutions, they have standard form arbitration clauses. You don't, as a weaker party or as a contracting party, have much bargaining power there. But the process has to be seen as being independent. The process has to be seen as being above board. So even though a clause may provide for certain persons to act as arbitrators, if those persons are not independent and impartial, surely you cannot be bound by the clause. That's the ethos and that's the rationale behind this. Is there anything else?
Anirudh, you want me to read it? I'll read the question that's put in the chat.
Yes, ma'am.
Yeah. Is there any formal requirement or format under the Act to obtain affirmation from the arbitrator regarding his independence?
Yes, ma'am. That's so formal requirement or format is what is there in the sixth schedule. Beyond the sixth schedule, the Act does not really prescribe any other formal requirement or format.
The other question is, with the disqualification stipulated in the schedule, can impartiality be enforced through the procedure rather than restricting appointments? The context is maritime and ISDS.
I'm sorry, I didn't. Is that on the chat box?
Sorry. Yeah, I think it's there. With the disqualification stipulated in the schedule,
Yes.
can impartiality be enforced through the procedure rather than restricting appointments? The context he has given is maritime.
So, well, in fact, in this context, the fifth schedule, there is a specific explanation which is related to maritime arbitration. And it clarifies that in maritime arbitrations, there is a practice to draw arbitrators from a small specialized fields. And if in such fields it is the custom and practice for the parties frequently to appoint the same arbitrator in different cases, then that is a relevant fact to be taken into account. That's explanation 3 to schedule 5.
Thank you. And there's one more question, and that's the last, I think. If the consensus to appointment of arbitrators is not reached upon by the parties, within what time and how the parties should approach the court for appointment of arbitrators?
Well, the Supreme Court, in the case of Datar Switchgear, said that if consensus is not reached within 30 days, then you can approach court. But that period of 30 days is something which is at a minimum required to reach the consensus. Your application may be premature if you go before 30 days.
Okay, I think we've covered all the questions. Thanks for your informative presentation. I'm requesting Ms. Saraswati to propose a formal vote of thanks. Thank you, Anirudh.
Thank you.
Thank you so much, Madhu, and very big thanks to Mr. Anirudh Wadhwa. A wonderful presentation, very given the limited time. He had almost touched upon the various aspects, how critical, how the law has evolved, and why this impartiality and independence matters a lot in the alternate dispute resolution today, and to ensure natural justice. And this is very important for us now, especially at this point of time, even when the chamber is getting seriously into institutional arbitration, and there have been a panel of arbitrators registered with us as well. So we are also learning in the process. So a very big thanks to Mr. Anirudh. Thanks a lot for joining us. I know it's a bit of an odd timings, but still you have made it. And thanks to the technology, wherever we are now, at least we are able to get the benefit of listening to such things. Otherwise, in a pre-COVID or a non-COVID era, we would have probably limited ourselves at this point of time some physical interaction from within the region. So this is also expanding our scope of listening to more experts. I'm thankful for that, and thanks to you. I should also thank the other Anirudh, our council member, who helped us in getting this Anirudh. So thanks a lot for Mr. Anirudh, though he's not present here today, and also the entire arbitration council. And I should thank the registrar, Ms. Madhumati, who had put together the program along with the team. And a big thanks to all the participants. Thanks for staying back, and await our next session. This is the 5th session, and we will shortly be inaugurating the center. I would extend an invitation to Mr. Anirudh and all of those who are present today. We will be before the end of this month. And I think with this, I wish you all a very, very happy, safe new year. Last year had been a bit very unusual and probably made all our plans go for a 6. Hope this year life will come back to at least the normal and peaceful. Thank you so much. Have a good, safe year, everyone. Thank you.
Thank you, ma'am. Thank you.
Madhu, will you stay back for a minute? Is she there?